Mr. Chief Justice, Your Honors, may it please the Court. I'm Elizabeth McBride, representing the appellee, Linda Ellis, along with Mr. Timothy McCormack, appearing as amicus curiae on behalf of himself, McCormack Intellectual Properties, and others, and in support of Ms. Ellis. I respectfully thank the Court for this opportunity to offer oral argument on behalf of Ms. Ellis. I've been asked to speak about and briefly discuss the factual background of this case because I represented Ms. Ellis at trial, as the Court is aware from reading the transcript. I will only take a small portion of time and allow Mr. McCormack to address the constitutional issues before the Court today. The facts which existed at the trial of this case, at the time of trial, and which exist today, continue to give rise to the need for Ms. Ellis to be protected by the stalking protective order issued by the trial judge, Judge Frank Jordan. After understanding the level of cyberbullying taking place on Mr. Chan's website, it's clear that the judge issued not only a necessary order, but an appropriate one that was not overly broad in this case. When Ms. Ellis approached me to handle the case, because I practice mainly in domestic relations, I said I've had limited involvement with stalking protective orders. They're normally done by pro se litigants. She asked me to take the case because she was afraid to face Mr. Chan in the trial. At that juncture, she had already obtained the first part of a protective order, which is the temporary protective order, where she went to the presiding judge that week on an ex parte basis and had a temporary protective order. And that temporary protective order I mentioned procedurally because it was then served on Mr. Chan along with a notice of the hearing seeking the permanent order so that he would have an opportunity to appear and present evidence and bring his counsel if need be. At the trial, Mr. Chan freely admitted to numerous of the posts that Ms. Ellis felt and the court found placed her in reasonable fear of imminent harm to her safety and well-being and to that of her family. It was not just one isolated, taken out of context posting concerning death. It was several postings referring to her death in some form or fashion.
Well, counsel, isn't the context a little problematic for your client? I mean, the poem that she's known for is about death. It's about a tombstone. And so frankly, when I looked at a lot of these posts that are included as exhibits, they appear quite clearly to be kind of plays on the words of her poem.
Well, Your Honor, if you look at some of the postings and one that was testified at trial, there was one posting stating, "Ellis, we are coming to get you." And then it had a link to a playing of the hearse song. And the words of that song are, "Don't you ever laugh as the hearse goes by, for you may be the next one to die." They wrap you up in a big white sheet from your head down to your feet. They put you in a big black box and cover you up with dirt and rocks. Now, it could be that they are playing on the dash poem. That's true. But what if they are trying to scare her by playing on words in the dash poem? If you take that with several of their other postings, which was a repeated over several months, even years of postings talking about going after her, he said, Mr. Chan admitted to saying, "So there are people who hate you and looking to put you in the ground." You've seen the sexually explicit photograph involving ready, aim, fire.
Sexually explicit. I think people post pictures of other people, you know, in that sense all the time.
Yes, sir. That post by itself, I can understand the court's concern about that, and I was concerned about that too. And in fact, I questioned Ms. Ellis pretty closely about that, but when you go on to look at the threats against her family, in one posting he says, "I predict there will be some collateral damage to innocence on her side, but it doesn't matter to me. This could mean exposing information on her family members."
Right.
Now that's
in context, exposing information. Do you think it can be stalking to expose information that may damage somebody's reputation?
No, sir, obviously not. But
so where is it a threat to the family to do something other than to embarrass or expose embarrassing information.
Well, in another posting, and this is one of several postings, he said, Mr. Chan said, "But I will leave you with a few nuggets to let you know I mean business. Some of this will mean very little to most people, but you should get it." And then he lists 4 things. 1, Linda Marie Hicks Ellis, 50, referring to her name and age. 2, David Lynn Ellis, 52. He knows who her husband is. 3, MEE, the initials of her daughter, and then museum, the word next to it, where her daughter works. 4, Roswell Downs, her subdivision. So they know about her subdivision. And in another posting coupled with that, because it is the totality and the pattern of these postings that created the fear, not just 1 or 2 of them. In another posting, entitled, "Matthew Chan Visit Linda Ellis's Hometown of Marietta, Georgia." Mr. Chan put on there, "I'm not going to say where exactly in Marietta I was, but let's just say I was in East Cobb, very close to the Kroger grocery store, essentially a short distance from Roswell Downs." So he knows about her daughter. He knows where her daughter works. He knows her husband. He knows her subdivision. They brag about driving by her house. So yes, he also bragged that he was a cult leader capable of influencing many other people, and he admitted to that. So the totality of that together with numerous other postings created the fear of imminent harm because they can show up at her house anytime.
But let me ask you, my fundamental question is whether all threats equate to stalking. This was posted on a static website. Unless somebody actually goes to the website and sees it, they have no knowledge of these perceived threats. So does he, by virtue of posting this information on a website, follow, place under surveillance, or contact another person?
The posts themselves do not necessarily constitute stalking, but if the internet is used as a tool with several factors together, where she knows that at any time they can go looking for her home, for her daughter.
If he climbs a mountain with a megaphone and yells out the exact same thing, is that stalking?
In that context, no, because you are not reaching billions of people on the internet as a self-proclaimed cult leader who can influence many, many others.
Reaches hundreds. Is it stalking?
Again, it would be up to the trial court, within the discretion of the trial judge, to judge the demeanor
The
of
operative
how
language in the statutes follows, place under surveillance, or contact.
But the trier of fact has to observe the demeanor of how fearful the...
No, it's reasonable. It's not, it's reasonable fear. I don't know how demeanor makes any difference at all. You should be able to get a stalking order with or without anything from the victim other than evidence. What about a Wikipedia page? A Wikipedia page that in great detail identifies you, your age, your family members, where you went to school, where you live, maybe it links to your Google Map picture of your residence, and also includes lots of information about how your opinions have been criticized horribly by people and how that you're the worst affront to the American judiciary and should be removed from office, and you're a disgrace and an embarrassment. Is that stalking?
That would not be, but Chan's...
Why?
Because the stated purpose behind it is not to intimidate a person over repeated contact through the internet, having other people join in for the purpose of having her not seek compensation for her intellectually protected copyrighted work.
The first thing I get if I Google, say, Clarence Thomas, is his Wikipedia page.
The Wikipedia page would not be, the intent of the Wikipedia page is not to scare him and harass him and intimidate him.
Well, what if it were? What if whoever created the Wikipedia page, that was exactly their purpose?
Well, it's more than that. This website is a fluid website where people are jumping on the bandwagon all the time with the stated purpose of intimidation that they control and can delete postings from, and their whole purpose is to scare her.
I mean, I can go create a Wikipedia page. They may take it down, but I can go create a Wikipedia page. What if I do that with the purpose of upsetting the subject? And that's my only purpose.
Well, that would not be sufficient to rise to the level of stalking, but if the purpose is to create imminent harm, and if in fact she reasonably feared for her safety because of her home and her family members, then the trier of fact had discretion to enter the protective order.
Do you agree that safety requires, is a threat of physical harm? Or do you think that the stalking statute is enough that your reputation is damaged?
She was afraid they were coming to her house, and I believe she testified that at one point she pulled up to her home one night.
I didn't ask what she was afraid of, just as a matter of statutory interpretation.
It would be a physical harm, threat of physical harm.
Okay,
Yes, sir.
because otherwise, all the stuff, the vast majority of stuff on this website is trying to get people to stop doing things and threatening economic harm to them, reputational harm, and so forth. You don't think that 90% of the posts on the website, even though they are threatening in the broad sense of you're bad and you should not do what you're doing, you don't think those would entitle someone to get a protective order?
The intent behind the website is to scare her to the point where we might come to your house, so that to take any measure necessary to scare her so she'll back off on seeking compensation for copyrighted materials. On that note, Your Honors, I would like to turn this discussion over to Mr. McCormack, who will address the constitutional issues. I thank you.